stop what you are doing right now. Because what just happened inside a federal courtroom in the last 72 hours is something that the people closest to power in Washington did not want explained clearly, did not want broken down in detail, and absolutely did not want reaching the tens of millions of Americans who will be directly affected by what comes next. A federal judge, not a politician, not an activist, not an opposition spokesperson, a sitting federal judge with lifetime tenure and the full weight of the American judicial system behind every word, has just ordered an investigation into what legal filings are describing as a billion-dollar fraud operating at the highest levels of the United States government. And the specific word used in the court order is not alleged. It is not suspected. The order uses language that federal judges use when they have reviewed the evidence and determined that what they are looking at is serious enough to require the full machinery of judicial investigation to be brought to bear on it. This is not a political story. This is a legal story with political consequences so large that the tremors from what was just set in motion are going to reach every branch of government, every financial market with exposure to American political stability, and every international relationship built on the assumption that the American legal system operates independently of the people it investigates. What you are about to hear is the full breakdown, the legal architecture, the financial anatomy, the political consequences, and the global implications of a court order that may ultimately prove to be one of the most consequential judicial actions in a generation. Do not leave before the end, because the final piece of this story, the specific mechanism by which $1 billion allegedly moved and where the evidence trail leads, reframes everything you thought you understood about what has been happening in Washington. Subscribe to this channel right now and turn on the bell notification. Legal and governmental developments of this magnitude move through the system in ways that most coverage fails to track properly. Court filings, evidentiary hearings, judicial orders, appeals, stays, recusals. The machinery of a federal investigation operates on a timeline and through a procedural architecture that requires ongoing detailed analysis to follow accurately. The people subscribed to this channel get that analysis as it happens. Subscribe now and let us get into this. To understand why a federal judge ordering an investigation into financial conduct at this level of government is as significant as it is, you need to understand what it takes to get there. Federal judges do not issue investigation orders casually. They do not respond to political pressure, to media coverage, to public opinion, or to the preferences of either party in a dispute. What moves a federal judge to issue an order of this nature is evidence. Documented, submitted, legally reviewed evidence that meets a threshold the judge has determined is sufficient to justify the extraordinary step of deploying the investigative authority of the federal judiciary into the financial affairs of the most powerful office in the world. The bar for that threshold is not low. It is deliberately structurally high, which means that a judge who has crossed it has reviewed what was placed before the court and made a determination that what sits in those documents is not speculation, not political grievance, and not legal theater. It is a factual record serious enough to warrant the full weight of judicial scrutiny. The financial conduct at the center of this court order involves a set of transactions, transfers, and financial arrangements that plaintiffs and their legal teams have spent months assembling into a documented evidentiary record. The scale, described in filings as reaching into the billions, is not a rhetorical flourish. It reflects the actual numerical magnitude of the flows being investigated, flows that allegedly moved through structures with connections to government policy decisions, regulatory actions, and financial instruments in ways that the plaintiffs argue constitute fraud at a scope that has no modern precedent in American executive branch history. The word fraud in a legal context is precise. It does not mean a bad deal. It does not mean a policy disagreement. It means the deliberate misrepresentation of material facts for financial gain, a specific, provable criminal allegation that, when a federal judge determines it warrants investigation, sets in motion a legal process that does not stop because the subject of the investigation is politically powerful or politically connected. Let us talk about the specific architecture of what is alleged, because the details matter enormously, and most coverage is deliberately vague about them in ways that obscure rather than illuminate what is actually at stake. The financial arrangements under judicial scrutiny involve the intersection of government policy decisions and private financial instruments in ways that, if the evidentiary record holds under judicial review, would represent the most direct and documented case of executive branch financial self-dealing in American history. Specifically, what is alleged is that policy decisions about tariffs, about regulatory frameworks, about the direction of federal financial engagement with specific industries and specific international partners were made, timed, or structured in ways that generated measurable, traceable financial benefits to private entities with documented financial connections to the decision makers themselves. The legal term for this structure is not complicated. When public power is exercised in ways that generate private financial benefit to the person exercising that power, the law has a name for it, and that name is what appears in the court filings that triggered this judicial order. What makes the billion-dollar figure not rhetorical but analytically significant is the mechanism through which that scale of financial benefit is alleged to have been generated. This is not an allegation about a modest conflict of interest, about a regulatory decision that happened to benefit a connected party, about the kind of gray area conduct that Washington has normalized over decades of revolving doors and soft influence. What is alleged here is a systematic, structured, repeated pattern of conduct in which specific policy levers that move markets, redirect capital flows, and reshape entire industry economics, were pulled in ways that generated returns at the scale that only government power is capable of producing. A tariff decision affecting hundreds of billions of dollars in trade flows can generate financial returns for a positioned investor that dwarf anything available through normal market participation. A regulatory action that clears the path for a specific transaction can create value that did not exist the day before the decision was made. A government contract, a licensing decision, a sanctions waiver, and export authorization. These are instruments of policy that are simultaneously instruments of enormous financial power when wielded with foreknowledge or with intent to benefit connected parties. The allegation is that they were. If you are still watching, you already understand that what is unfolding inside this federal investigation is not a political skirmish. It is a constitutional reckoning. Subscribe to this channel right now, because the evidentiary hearings that will follow this judicial order, the discovery process that the order sets in motion, the financial records that will now be subject to judicial subpoena, all of it is going to produce developments that require exactly the kind of detailed, serious analysis you are receiving right now. Turn on the bell notification. The next chapter of this story arrives without warning and without a convenient news cycle. Be here when it does. The discovery process that a federal investigation order sets in motion is one of the most powerful legal mechanisms in the American judicial system. Once a federal judge has ordered an investigation of this nature, the court has the authority to compel the production of financial records, communications, internal documents, and testimony that would, under normal circumstances, be shielded by executive privilege claims, attorney-client privilege assertions, and the general opacity that surrounds the financial affairs of powerful private actors. The question of how far those compulsory powers extend when the subject of the investigation holds executive authority is one of the most contested areas of American constitutional law, and it is a question that the Supreme Court has addressed in ways that leave significant ambiguity about exactly where the boundaries lie. That ambiguity is not an accident. It is a feature of a constitutional system that has never fully resolved the tension between judicial authority and executive power, between the independence of the courts and the institutional interest of the executive branch in limiting the scope of judicial scrutiny over its own conduct. What happens when a federal investigation order collides with executive privilege, claims of the breadth that this administration has historically asserted, is a legal confrontation that will move through the courts at a speed determined not by political urgency, but by procedural architecture. Motions to quash, appeals, stays of discovery pending appellate review, emergency applications to circuit courts, potentially a return to the Supreme Court on questions about the scope of executive financial disclosure obligations. The road from a judicial investigation order to a final adjudication of the underlying allegations is not a straight line. It is a contested terrain with multiple points of potential delay, obstruction, and reversal. But here is what the delay strategy does not change. The order exists. The investigation has been authorized by a federal judge who reviewed the evidentiary record and determined it was sufficient. The legal process that has been set in motion does not unset itself because the subject of the investigation is politically powerful, or because the administration deploys every available legal tool to slow its progress. Delay is not dismissal. Obstruction is not exoneration. And the financial record that forms the evidentiary foundation of the judicial order does not become less real because the investigation takes longer than the political news cycle to resolve. The congressional dimension of this judicial order is where the political consequences begin to crystallize in ways that will reshape the operational reality of governance in Washington for the foreseeable future. Congressional oversight committees in both chambers now have a significantly strengthened legal foundation for their own parallel investigative processes. A federal judge's determination that the financial conduct described in the filings warrants investigation is not binding on congressional committees, but it is extraordinarily useful to them. It provides judicial validation for document requests, subpoena issuances, and witness compulsions that might otherwise be challenged as politically motivated fishing expeditions. When a federal court has already determined that the underlying conduct is worth investigating, the argument that congressional investigators are engaged in political theater becomes substantially harder to sustain in front of a federal judge reviewing a subpoena challenge. The specific committees with jurisdiction over the financial instruments at the center of this case, the banking and finance committees, the oversight committees, the judiciary committees of both chambers, are now operating in an environment where their investigative authority has been implicitly validated by a coordinate branch of government. The document requests that are already in circulation, the witness appearances that have already been demanded, the financial disclosures that have already been sought, All of these now exist in a legal landscape that a federal judge has just shifted in favor of the investigators and against the investigated. The international dimension of this judicial order is the part that most domestic coverage ignores entirely, and it is where the global consequences become visible. Foreign governments, foreign investors, foreign central banks, and foreign intelligence services all maintain continuous assessments of the stability and integrity of the American legal and governmental system. Those assessments inform decisions about dollar-denominated asset holdings, about the credibility of American commitments in treaty and trade contexts, about the risk premium attached to American political uncertainty in financial modeling, and about the fundamental question of whether the American system of law operates independently of the people it governs, or whether power in America insulates rather than exposes the powerful. A federal judge ordering a billion-dollar fraud investigation into the conduct of the sitting presidency sends a signal through every one of those assessment frameworks simultaneously. For some audiences, memory Kunter and I enter primarily allied democratic governments that share American commitments to rule of law principles, the signal is reassuring. It demonstrates that the American legal system retains its independence and its willingness to apply judicial scrutiny to executive conduct regardless of political consequences. For other audiences, governments that have been watching American political instability with a combination of concern and strategic opportunism, the signal carries a different meaning. It adds another data point to an already substantial record of American institutional stress. It raises the risk premium on American political stability in ways that eventually find expression in currency markets, in bond yields, in the calculations of foreign direct investment, and in the diplomatic calculations of governments deciding how much weight to give American commitments. The market response to the judicial order, while not dramatic in its immediate expression, reflects the underlying uncertainty that a development of this nature introduces into the risk environment. Political risk in the world's largest economy is not a factor that financial markets can price with precision. It is a factor that they discount broadly, applying wider spreads, shorter duration preferences, and more conservative positioning across instruments with exposure to American political outcome uncertainty. The billion-dollar fraud investigation order did not crash any market, but it added to the weight of uncertainty that has been accumulating in the American political environment, and weight accumulates until it moves something. The constitutional scholars who have been tracking this judicial order since it was issued are not using measured language in their private assessments. What is happening, a federal court asserting investigative jurisdiction over financial conduct at the executive level at this scale, has limited historical precedent. The Watergate investigation involved financial dimensions, but was fundamentally a political corruption and obstruction case. The Clinton financial investigations of the 1990s involved personal financial conduct prior to the presidency rather than conduct intertwined with the exercise of presidential power. What is alleged here, the use of governmental policy levers as instruments of personal financial enrichment at the scale of billions of dollars, sits in a category that the American legal system has not previously been required to adjudicate at this level of the government and at this scale of alleged conduct. The legal frameworks exist. The constitutional principles are established, but the specific application of those frameworks to conduct of this nature at this level, at this scale, is territory that the courts are now being asked to navigate in real time under the full pressure of a politically polarized environment with consequences that extend far beyond the immediate legal question. What happens next is not a single event. It is a cascade. The administration's legal team has already begun the process of constructing the procedural obstacles that will slow the discovery process and challenge the scope of the judicial order. Those challenges will move through the appellate system on a timeline measured in months. Congressional investigators will use the judicial order as leverage in their own parallel processes, and the administration will resist those processes using the same executive privilege architecture it deploys against the judicial investigation. The financial institutions whose records are now potentially subject to judicial subpoena, the banks, the investment vehicles, the financial intermediaries whose transaction records form the evidentiary backbone of the underlying allegations, will have their own legal teams navigating the intersection of their disclosure obligations, their customer confidentiality commitments, and their risk of becoming collateral damage in a legal conflict between branches of government. And at the center of all of it, a federal judge's order sits in the record of an American court, signed, dated, legally operative, representing the determination of a judicial officer who reviewed the evidence and decided that what was placed before the court was serious enough to warrant the full investigative authority of the federal judiciary. That order does not go away. It does not expire. It does not become less real because the political environment makes acting on it complicated. It is the foundation on which everything that follows will be built. Here is where this stands right now. A federal judge has issued an investigation order into financial conduct described in court filings as reaching the scale of $1 billion, involving the intersection of governmental policy decisions and private financial benefit at the highest level of the American executive branch. The discovery process authorized by that order is now subject to legal challenge from the administration. Congressional oversight committees are using the judicial order to strengthen their own parallel investigations. International observers are updating their assessments of American political and institutional stability. Financial markets are adding the uncertainty to an already elevated political risk environment. And the legal and constitutional questions raised by the case have no clean precedential answers, meaning the courts are being asked to write new law about the limits of executive financial conduct in real time. The people who will be affected by the outcome of this investigation are not abstractions. They are the Americans whose government this is, the taxpayers whose financial system is implicated in the alleged conduct, the citizens whose institutional trust in the independence and integrity of American governance is either validated or further eroded by how this unfolds, the global partners whose confidence in American commitments rests partly on the assumption that the American system corrects rather than protects misconduct at the highest levels. This is not the end of this story. It is the beginning of the part that matters most. Subscribe to this channel right now if this breakdown gave you a framework for understanding what is actually at stake in this judicial order. Turn on the bell notification, because the evidentiary hearings, the appellate decisions, the congressional responses, and the market reactions that follow this order are going to require ongoing, detailed, serious analysis. And this channel is where that analysis lives. Share this video with everyone in your life who wants to understand what is happening in American governance beyond the partisan noise and the surface level headlines. Comment below with your assessment of where this legal process leads, because the conversation you start in the comments is the conversation that serious people everywhere are already having behind closed doors. And stay close, because what comes next in this story may make what we just discussed look like the opening move of something that reshapes American governance for a generation. The investigation has been ordered. The process has begun, and nothing that happens next will happen quietly.